So, you think you've got it all figured out? You believe you have a solid plan in place for your future, especially when it comes to your healthcare decisions? Well, Kansas might just have a different perspective on that. Let's talk about Sarah. Sarah is a resident of Wichita, Kansas. She's intelligent, she's proactive, she's prepared, and importantly, she has a living will. A legally binding document that clearly and explicitly spells out her wishes regarding medical treatment, specifically in the event that she is unable to communicate those wishes herself. It clearly states, if I am diagnosed with a terminal illness, I want to be allowed to pass away peacefully, with dignity. Seems perfectly sensible, doesn't it? But here's where Kansas law throws a wrench in the works. Because in Kansas, if Sarah happens to be pregnant, her carefully considered plan can simply be ignored. That's right. The current state law explicitly says that her living will is essentially null and void. It simply doesn't count if she's pregnant and carrying a child. So what about her wishes? Overruled by the state. And her body? It's potentially managed, or at least heavily influenced, by the state government for the entire duration of her pregnancy. That's 9 long months. And this isn't some archaic, long-forgotten law that's been gathering dust on the books. This is a current, active law that has women all across Kansas feeling angry, frustrated, and rightfully so. Just imagine for a moment making some of the most difficult, heart-wrenching decisions about your own life, your own body, only to be told by the state government that, actually no, we don't care what you've decided. We, the state, will decide what's best for you. Your personal input? It's noted, but ultimately dismissed and disregarded. This is a fundamental fight for autonomy, for basic human dignity, and for the fundamental right to have control over your own body and your own healthcare decisions. Living wills are ultimately about your body, your life, your choice, your decisions, and your inherent human dignity. But in this case, Kansas law actively steps in, prioritizing the rights of the fetus over the clearly expressed wishes of the woman carrying it. And what's the ultimate result of this? It means that women's end-of-life healthcare decisions are effectively no longer their own to make. Unsurprisingly, this law is sparking widespread outrage and is now the subject of a major legal battle. Women across Kansas are demanding that their voices be heard and respected even, and perhaps especially, when it comes to end-of-life care. So the central question remains, should the state government really have the power and the authority to unilaterally override your most deeply personal healthcare decisions? For a great many people living in Kansas, the answer to that question is a resounding and unequivocal no. The fight is officially on, and the stakes in this battle simply couldn't possibly be any higher. This isn't just about filling out paperwork and signing forms. It's fundamentally about who ultimately gets the final say in the most intimate and personal aspects of your life. And here in Kansas, that particular answer is still very far from being settled. While the current law is undeniably clear, so too is the fierce opposition to it. The ongoing battle for bodily autonomy and reproductive freedom is only continuing to heat up and intensify. And in many ways, this is only just the very beginning. Let's break down the Kansas law. If a woman is pregnant, her advance directive her living will can be ignored if life support is needed for the fetus. Her right to refuse treatment? Suspended. As Danielle G., a plaintiff, put it, "This law treats me like an incubator, not a person." The law's existence alone creates anxiety for women, knowing their wishes might not be honored. It's a constant, looming threat to their peace of mind. 5 Kansas women are suing the state, demanding change. They're not just making legal arguments. This is personal. Danielle G. wants her end-of-life wishes respected for her family's sake. Audra D. fears being forced to suffer if incapacitated and pregnant. Their goal, reclaim bodily autonomy and equal protection. They argue the law discriminates against pregnant women, treating them differently from everyone else. They're fighting for all women in Kansas to have their choices respected. This law isn't just a simple disagreement. It's a complex legal and ethical mess, a minefield of conflicting principles and unintended consequences. It raises profound questions about the role of the state, individual liberty, and the very definition of personhood. It pits the state's asserted interest in fetal life, often framed as protection, directly against a woman's fundamental right to control her own body and make deeply personal medical decisions. Doctors caught in the middle face impossible choices, whether to honor their patients' wishes and medical needs or strictly obey the dictates of the law, potentially harming their patient. Kansas isn't alone. This isn't an isolated incident. Other states have enacted similar laws, creating a patchwork of restrictions across the country. But legal challenges to these laws are growing, fueled by concerns over constitutionality and ethical implications. Imagine if men faced this same level of intrusion. What if a man's clearly stated living will could be summarily ignored simply because he once made a sperm donation? Ridiculous, right? Utterly absurd. Yet for pregnant women, this is the chilling reality they navigate. These laws effectively create a second class of citizens, stripping them of fundamental rights, particularly when it comes to critical end-of-life planning and healthcare decisions. The fight is fundamentally about equality, bodily autonomy, and the protection of basic human rights for all. This isn't just a Kansas issue. It's a matter that resonates far beyond state lines. The decisions made here have the potential to influence similar cases across the nation. It's part of a national debate, a complex and ongoing discussion that touches upon fundamental freedoms and legal interpretations. On women's rights, a cornerstone of equality and personal liberty that has been fought for and defended for generations. And bodily autonomy, the right to make informed decisions about one's own body and health, free from coercion or undue influence. Legal battles like this, these courtroom showdowns, set precedents for the whole country, establishing legal guidelines and interpretations that can shape future rulings and policies nationwide. If the law is struck down, it could help challenge similar laws elsewhere, providing a legal basis for overturning restrictions in other states facing similar challenges. If upheld, it could inspire stricter controls, potentially leading to a wave of restrictive legislation in other states seeking to limit individual rights. At its core, this is about who controls your body at the end of life, during the most vulnerable and critical moments when personal autonomy matters most. You or the state? The answer will shape not just Kansas, but the future of personal rights in America, setting a precedent that could either expand or restrict individual liberties across the nation. The implications are enormous, for everyone, regardless of where they live or what their personal beliefs may be. This decision will impact us all.